Good morning, everybody. Welcome to the 5th DCA. I've been introduced. Let me introduce my colleagues. To my right is Judge Eisnagel, and to my left is Judge Harris. First of all, if you have any electronic noisemakers, please turn them off or put them in the silent mode. We've had one case that was set for today has been continued, the Zeef versus Pettit case. So if you're here for that, you may want to go check with the clerk's office to see what the new arrangements are. Each side on all these appeals will have 20 minutes. And if the appellant will let me know if they want anything other than 5 minutes for rebuttal time. And with that, we're ready to proceed on Cook versus State.
May it please the court, counsel. My name is Anthony Candela and I represent KYANDREA Cook. This appeal comes to this court via a motion to withdraw a plea that was denied. The procedural background of this case is a little bit necessary to understand how we got to where we are and what we're arguing about today. Ms. Cook was involved in a scheme in which she was charged as a principal in a carjacking, attempted carjacking, and an aggravated battery, the latter two charges with a deadly weapon. She was the hook, the lure, whatever you want to call her. She was the person who was image and profile was used on a dating app called Meet Me, in which the unsuspecting bachelors would see her profile, she would talk to them, she would lure them to a location, and her boyfriend and some other ne'er-do-wells would then committed these offenses. She was arrested, and her case began to work through the system. On June 27th of 2017, she pled open. This was a short time, very, very short time after her arraignment with the assistant public defender, and she got a total of 20 years as a result of that open plea.
All right. And at that time, she then moved to set aside, withdraw her plea because she had a voicemail saying you're not going to get prison time?
Well, there's a couple of different things. That is one point, Your Honor. The other points I wanted to make was that I think she was barely over 18. She was still in high school. And had never been in trouble before with the system, which I think those factors become important down the road. She does retain a private attorney shortly thereafter, and he files a motion to withdraw a plea. The motion to withdraw a plea is in the record. I believe it's on page 54 of the record. It's not a very factually diverse motion. It's pretty boilerplate, but it does lay out that she believes that she was misled into pleading. A couple months later, the judge has a hearing and determines at the end of that hearing that she'll be allowed to withdraw her plea. But what's important about that hearing, and that's on 263 and 264, is the court's ruling. The standard is court wears manifest injustice, whatever the heck that means. Okay, no court in the state of Florida has defined what manifest injustice is. The Florida Supreme Court, in dealing with 3.170L, kind of plucked that out of its own body of cases, and then coupled it with prejudice. We know what prejudice means, but we don't know what the manifest injustice goes to, whether it's substantive, whether it's procedural, whether it's a complete jettison of what should happen in a hearing. We have no idea. So that goes on. The judge makes his ruling, and the judge, it's unclear from the ruling whether or not he found manifest injustice. However, he withdraws the plea, and her case begins to go forward. Fast forward 4 months from then, we're now in January of 2018, and with the private attorney, Ms. Cook again pleads open, provides some information. A PSI is ordered, and then the wrinkle is she is arrested because her bond is revoked because of some
She violates the conditions of her release.
Well, and it looks like, and it's a pretty serious one because she's contacting the boyfriend, or the boyfriend's contacting her. It wasn't clear from the record, and it wasn't clear from the hearing, but there's some contact with the co-defendant who she's not supposed to have any contact. She's then put in jail. And she remains in custody until the sentencing on April 9th. And the April 9th sentencing is one of the stranger, having done this for a few years, one of the stranger open plea hearings I've ever seen. There's no mitigation put on. She says relatively nothing. The state gets up and makes a recommendation. There's no evidence put on whatsoever. And then the judge then changes the sentence to 20 years of probation with a term and condition of that as being 11 years in prison. And then she files, she sends a letter, which is what precipitated this going forward, in which she, and two parts to it. First part, she says she puts in an appeal. There is no notice of appeal that was filed by her. It looks like the judge construed this letter to be a notice of appeal and then directed this to go forward. Didn't address the other part of the letter. The other part of the letter is the part that when I was appointed, I began to push forward, and this court relinquished jurisdiction to have the trial court take a look at, is the statement where she says, my lawyers basically made me take the plea in which I am not satisfied with. The trial judge, then taking a look at it, said, I believe this is factually insufficient, had no hearing on the matter, and then also cited to the Harris case out of the 2nd District. I believe the Harris
Didn't he
case,
say it was rebutted by the record?
He did, but we're dealing...
By the colloquy, right?
Correct, but the
And then he said as an alternative, it's insufficient.
Correct, but the gravamen of what I'm saying is that this is a 19-year-old at this point, never been in trouble before, hires an attorney to represent them, ends up in almost the exact same position because that she was the first time around, and then basically says, I wanted to read a letter. Basically, I wanted to give an allocution, and my attorneys wouldn't let me do that. I think the court, at that point, should be having a hearing to determine what's her gripe about this. I'm not trying to open the flood doors to every time some defendant has an objection to their sentence, but she's saying, I was forced to do this. And that's why I said...
But that's the whole reason behind the plea colloquy, where the judge asks, have you been forced, promised, all the rest of this? You do it one time, and then you find out she was, and maybe it's a little too strong to say promise, but her attorney strongly suggested she wouldn't get any prison time, and she was looking at 20 years, right? So, okay, once bitten, twice shy, I guess not. Next time around, another plea colloquy, where you promised, threatened, all the rest of that. No, no, no. I don't like my sentence. I guess I was pressured into this. So what's the purpose of doing a plea colloquy?
Well, a couple of different things. As driving over here, I thought about this, and then another case popped into my head that I did not brief for this court, was the LaRoe case from the Florida Supreme Court, dealing with attorney misinformation in the Supreme Court of Florida. In that
Stick
case...
to what you did brief.
Well, I apologize. I didn't brief that, but it occurred to me that you may ask me about, in that case, just in a nutshell, the Florida Supreme Court said there's a difference between when you hire an attorney, you're relying on their information to you as an expert. That's the point I was making with her. She's 19-year-old.
Well, for the first time around, I get that, because that was affirmative misadvice. That was brought to the court's attention, and the plea was allowed to be withdrawn. Here, it says I was forced, but doesn't say what happened. If it said I was forced, they did X, Y, and Z, that's one thing. And the other thing, did counsel or she request leave to file a facially sufficient or factually sufficient motion?
Again, goes back to this. She's a 19-year-old. She's sent off to prison. She's got no idea how the legal system works. She sent a letter that the court has that is what we're using to get to this point. Because if she's just appealing the judgment and sentence, there's nothing there. This is a Anders brief, and we're
Counsel,
not
below, if I recall, your client took the position that this letter could have been read as a notice of appeal, or equally could have been read as a motion to withdraw a plea, correct?
Yes.
Sort of 50-50?
Yes.
Well, what's the trial judge supposed to do, counsel? In a 50-50 position, from your view, it's 50-50.
Well, 50-50, I think.
Should the trial judge treat it as both?
Interesting.
Well, I'm asking you, what should the trial judge have done?
The trial judge could do both, Your Honor. Could do both. Could treat it as an appeal and have her come before the court to tell the court exactly what you mean by this letter. Because we're dealing with the Sixth Amendment here. Because the Sixth Amendment is going to require her to have a knowingly, intelligently, and voluntarily entered plea. She's forced into the plea.
So what will we call that hearing? There's this vague letter. Could be read as a notice of appeal. Could be read as a motion to withdraw a plea from your position. What do we call that hearing?
Well, it's no different than what the rule I cited, 3.170L, which is withdrawing plea after sentence.
Well, so you're saying that the trial judge should have just treated it as a motion to withdraw a plea.
A 2-minute, it's no different than having no different than in discovery problems, having a 2-minute Richardson hearing so that we could solve a problem. Bringing her in and saying, hey, what did you mean by this? And then she says, I'm just upset about my sentence. Well, then
so anytime a party files a vague document like this, the trial court has to hold a hearing to find out what they want to do?
Well, yes, I would say that because think of in Rule 3.850, if a facially insufficient motion for post-conviction relief is filed, SPIRA requires the court to say, hey, listen, this doesn't make out we're not sure what you're asking here, send it back and you have to do a facially valid one. The problem is...
Well, that's when it's clear that what the motion is, they just didn't make all the proper allegations, correct?
Yes, but most circuits have a form motion that the inmates follow when they're filing those, 3.850.
You think there would be a lot of hearings if we required the trial judge to hold a hearing every time that a pro se party filed a document that was unclear what they were seeking?
No, and here's why. This one was filed relatively quickly. If this was filed outside the time frame for a motion to withdraw a plea, which I believe is 60 days, you wouldn't address it. It would be untimely. An appeal has to be filed within 30 days unless, as this court is well aware, we have a lot of belated appeals from indigent defendants not realizing that they wanted to appeal or not telling their attorneys or whatever. But other than that, I don't think this would impact the court's daily business that often. It would be...
What's the court's role at this hearing? Is the court going to be standby counsel and sort of, lay out the options for the party or what?
No, I think the court would merely make an inquiry, just like as in any other inquiry, and say, hey, listen, you filed this letter. I'm just curious, or the court wants to know what is your purpose of this letter. If the person says, hey, I want to withdraw my plea, or I don't like, but I want to withdraw my plea, then you know that, hey, listen, this is kind of facially insufficient. I'm going to appoint counsel, ask you to meet with counsel.
What if the trial court doesn't get, the party already filed a letter that is vague, and the trial court says, your letter's vague, I don't understand the purpose of your letter. What if the trial court simply gets another vague answer?
Well, but then you've provided an opportunity to correct it, just like you do, and just like is required in the Spirit case for a 3.850. I think that would satisfy the requirements of, hey, we're put on notice that there might be a problem. We've asked, you haven't corrected it. I think we're done at that inquiry.
Your client knew what a facially sufficient motion to withdraw a plea looked like, right? One had been filed on her behalf just a few months earlier. So she'd seen one at least.
Your Honor, you're asking a 16-year-old to file a legal document. 1 year, 2 years earlier, she's a juvenile. I mean, with no height, didn't finish high school. I believe she finished high school in jail.
But based on what was filed, wasn't the court justified in finding that it was legally insufficient if it's to be treated as a motion to withdraw a plea? I mean, no factual allegations, not even a request to withdraw the plea. What's he supposed to do with that?
I understand the court's question, and I don't disagree that it was facially insufficient. Again, we're dealing with a 19-year-old with limited education trying to navigate the legal system, whereas to be an attorney, you have to go to college and go to law school and pass the bar. So we're dealing with a different standard, and that's one of the things that the state cites was the Harris case. Harris The attorney filed an insufficient motion, amongst other things. And they, you know, but when you're dealing with a 19-year-old and you're asking her to properly plead a motion to withdraw a plea.
No, we're not really, the question isn't she has to even properly plead it, right? I mean, it's more fundamental here than that. She didn't even ask. She didn't even indicate what the motion was, let alone plead it.
Again, but it goes
Right?
back to my uneducated 19-year-old with not even a high school education, never been in trouble with the system before, hires an attorney who's supposed to be their wealth of knowledge and their guide through the legal system. This person says, you know, essentially, hey, don't say a word. I've worked something out with the state. We're just going to sit over here.
Are you saying that she has grounds for post-conviction relief?
She might, but I think we'd be back here on the same issue. I wouldn't be back. We'd be back here on the same issue. If she had misadvice from her counsel, then she would fall under 3.850. She'd go back to the main case is LaRue, and she could say, hey, listen, he told me X, Y, and Z.
Well, she wanted to withdraw her plea, and her counsel just, you know, failed to file the motion.
Then she has a then that would be a factual determination for the court. But if she wanted to withdraw her plea and the counsel didn't move, either didn't file it or didn't move to withdraw,
Wouldn't that be a more appropriate proceeding to take this issue up?
It might, but that's not the factual scenario we have before the court. We have this letter from her saying she followed the procedure to put in an appeal, and that she's either griping about her sentence or asking to withdraw her plea.
Speaking about her sentence, before you're done, let me ask you this. You complain that this is a illegal departure sentence. How is that?
There was no, the sentence ended up being 20 years of supervision, Your Honor, with 11 years in the Florida State Prison. There was no, from the way I read the record, there was no reason given for the 20. Put the 11 prison away, because the 11 prison is a condition of the probation. And I think that if it was, my problem with it was that she scored prison. She got prison, but she got prison as a condition of her probation, not as a prison sentence followed by probation or followed by supervision in some fashion. So I think that the way that the
Saying that she got 11 years followed by 20, which is a total of 31 years, that's okay, but just this 20 years with 11 as a condition is an invalid departure?
No, it should, if the judge wanted to do what they did, the way to do it is, I'm not, would have done 11 followed by 9 if you were trying to make a 20-year sentence. 20 years as a probation, and oh, by the way, you're going to spend 11 of it in the Florida State Prison as a condition.
Did you raise in your brief that this was an illegal sentence because you had concurrent terms of prison and probation?
Yes. That's essentially what I was saying, was this is a departure sentence without a reason, because it's a probation sentence.
Well, is a departure sentence different than an illegal sentence?
Can be. It depends on how it's structured. But the court has to announce, if you're going to depart, the court's got to announce a departure that falls within one of the enumerated departures, or have evidence, and there's nothing put on at the hearing. So this is either agreed upon by the state or it's not.
You've got about 2.5 minutes left of your rebuttal.
May I reserve?
Sure.
Okay. Thank you.
May it please the court, Chris Davenport on behalf of the state of Florida. Let me just touch on this sentence issue. The only argument he made in his 3800B, and the only argument he made on appeal, is that this is an improper departure sentence. He never alleged it was illegal because of the way they structured it.
Is it illegal?
I don't believe so, but I haven't researched that, so I'm not positive you can do that. But nobody ever said that he didn't want to. The reason they did that this way is because the state agreed to this lower term of imprisonment because she's supposed to cooperate. So they put her on probation and made her a condition of probation that she cooperate and testify against the shooter. And if she doesn't do that, she's going to violate her probation, and they can deal with that then. That's why they structured it that way.
You also made a condition of probation that she serve 11 years in prison. How do
Right.
you complete probation while you're in prison?
I don't, off the top of my head, know the answer to that, Your Honor. And it wasn't raised. It
Y'all
wasn't
may wish
raised.
to look at the case Oliver versus State. That may shed a little light on it, but I don't think it was raised
Yeah.
properly in this case, in terms of that being per se an illegal sentence
Right.
to concurrently be in prison and on probation.
Right. I know there's law on that. I don't know what it is, but it wasn't raised as an issue, so that's why I don't know what it is. He said it was a departure, and it's not. It's a guideline sentence. As far as this letter, how you treat it, let me just say, I would treat it as a notice of appeal. I think that's within the judge's discretion. She said she filed this the day of her sentencing. They ended the sentencing with, if you want to appeal, you need to file a notice within 30 days. She says, Judge Foxman, just like you told me, I'm putting in for an appeal as instructed by you that has to be done within 30 days. And then she starts complaining about the plea. I would look at that and say, gee, that's a notice of appeal, and here's what she wants her attorneys to raise on appeal. And that's how the judge treated it. He also treated it, because we did a relinquishment, he also treated it as a motion to withdraw the plea. And he said it's refuted by the plea colloquy, which it is. This is not a bare-bones plea colloquy. This is her second time through. The judge knew that he needed to be careful because, you know, she was young and she had withdrawn her plea before, was very upset about it. So he went through it in great detail, and she was sworn in, and she testified under oath. I was not coerced. I had plenty of time with my attorneys. I understand what I'm doing here. I know that I face a life sentence. I know it's completely up to you how much time I'm going to get. I wasn't promised anything. I wasn't told anything bad. And this is a voluntary plea.
There was a written plea agreement, right?
The written plea agreement that she signed and that she said under oath, I read it and I understood it, also said the same thing. I wasn't promised anything. Nobody has promised me anything. Nobody has coerced me into doing that. There's many cases where this court has said that you don't need a hearing when it's refuted by the plea colloquy, as this one was. So in a sense, she got the best of both worlds. They treated it as a notice of appeal, and if they hadn't, this court wouldn't have jurisdiction, because that was it. She filed a more formal one later, but it was past the 30 days. So we treated it as a notice of appeal, which is exactly what should happen. Plus, we did a relinquishment, so he evaluated it as a motion to withdraw the plea, and it is facially insufficient, but more importantly, it's refuted by the plea colloquy. You know, you can't just go into court and then change your mind if you don't like the sentence later. The only specific allegation she has in here is they made me take it, which was refuted by what she said under oath at the hearing. And then they said, I don't like my sentence. My lawyers wouldn't let me read the letter, which, by the way, the letter's attached here, so the judge got the letter. She also spoke at her sentencing. The letter basically said the same thing. When I get out, whenever that may be, I'm going to, teach kids to not make the same mistakes I've made. And by the way, this sentence is really mean. That's what the letter says. That's not my plea was involuntary. That's, I have buyer's remorse now, and I don't like the sentence I got still, even though it's half what I got before. That's not a reason to withdraw your plea. If her lawyer told her something improper or lied to her about what she was going to get or forced her into doing that can all be dealt with in a 3850. Counsel has made it crystal clear he's not raising ineffective assistance on the face of the record here, nor could he, because there's not even allegation that the attorney did anything. If the attorney did something wrong, we have a process to take care of that, and that's a 3850. So it's not like she's stuck here if the attorney did something that they shouldn't have done. We submit that the judge handled this exactly as he should have. There's no reason to give her relief here. She got a fair sentence, a legal sentence. It's not a departure sentence, and she had a voluntary plea. 19-year-olds, contrary to what counsel says, can enter a plea. 12-year-olds enter pleas. There's no age limit on that. They don't get to withdraw it because they're young or because they don't like how it turned out. That's not how it works. If there are no other questions, we would ask the court to affirm. Thank you.
I would go back to, and that's what I was talking about before, go back to the ruling by the court the first time around on the motion to withdraw plea, where the court didn't find manifest injustice. So if you're saying, hey, listen, she's been through this before, All she knows from this, with no legal training, is that attorney made some sort of mistake and told me something that wasn't right. Now she's applying it a second time, thinking that my attorney didn't do what they were supposed to do, or forced me to do this, and that I should be able to.
But she entered an open plea. She faced life on the first count, I don't know if it's life or 30 on the second count, 15 on the third count, and she got 11. How could she establish a manifest injustice when she pled open, facing life in prison?
That's the question. What is a manifest injustice? Because when the way the rule reads is or the way the Campbell case enunciates it, it's a manifest injustice or prejudice. Manifest injustice in all of the cases on withdrawal plea under that rule have never been defined. We don't know, again, we don't know if it's substantive, we don't know if it's procedural, we don't know if it goes to the plea being knowingly, intelligently, and voluntarily entered.
Look, like I think Judge Eisnagel asked, what's the purpose then of the colloquy? I mean, as someone who's probably done 1,000 plea colloquies, what else was the judge supposed to do in this case? He was very detailed, thorough in his colloquy, plus the written plea form. He went through that with her. What else is he supposed to do to prevent this?
I'm at a loss. I don't know. I mean, you do this stuff and it can be rebutted. The plea colloquy is not. Plea colloquy could be conclusive evidence, but it can be rebutted if there's other. If the allegation is my attorney told me to stay quiet, then the plea colloquy has nothing to do with whether or not you were promised something or told something else by your attorney, and that would be facially sufficient to get a 3850 hearing. Whether or not you're successful at the 3850 hearing is a completely different story. But all I'm saying at this point is I think that this court. I would urge this court to remand for a hearing, have her appointed counsel, and see if that's what she was doing. She may say, no, I'm just upset about the sentence, and then that's done. There's nothing to appeal on that.
All right, thank you. Your time's up.